So we'll start with unit 3. Okay, unit 3 again is having different concepts. Some are related to will, which is sort of similar as compared to chapter 5. Okay, so will, we have like differences between will and gift, will made in deathbed, during willness, those provisions we have. After that, we have provisions with regard to gift or hiba, what we saw. So provisions, basically there are three things: essentials, kinds of hiba, and also revocation of a gift or hiba. These are the things that we are having. So we'll discuss essentials plus revocation of a gift. Discuss this kinds of hiba plus differences between will and gift. All right. So now with regard to gift or hiba, a gift is generally, we understand that transfer of property wherein we are transferring interest in that property. So interest is transferred from one living person to another without any consideration. In Transfer of Property Act as well, we have seen that even if you are taking very small amount also, which is not at all at the same level with what property you are giving or what object you are giving, but still you are taking some consideration. But gift, as we understand, generally is without any sort of consideration. It is a gratuitous or and interviewers in nature. Without expecting anything in return, you are doing it. Plus, it is interviewers between two living persons only. Like we have seen in case of Transfer of Property Act. Also, there are transactions interviewers, but in case of will, it is from one dead person, it is going to one living person. But in terms of gift, it is interviewers between two living persons. Transfer is taking place. This is the general definition that is accepted by all religions, including Muslims. That is what we commonly understand by the term gift, that something is given from one living person to another living person for free without expecting anything in return. In Muslim law, gifts are called hiba. The gifts in India are governed by Transfer of Property Act. However, the provisions of Transfer of Property Act does not apply to Muslim law. So there was this exception under Transfer of Property Act, which says that we are giving provisions with regard to gift. These provisions will apply in general for any other transaction or alienation of property between two persons. But with respect to gift, these provisions are not applicable when it is hiba. There was this saving clause under section 129 and chapter 7 of Transfer of Property Act, that whatever is applicable in Muslim law, those provisions remain as it is. We are not touching those provisions. But otherwise, for all remaining people, Transfer of Property Act will be applicable. The provisions of Transfer of Property Act does not apply to Muslim law. Muhammadan law defines hiba or gift as transfer of determination amount of property without any exchange from one person to another and accepted by or on behalf of the latter. So basically, you transfer your property without any expectation, without any sort of exchange, consideration, or without anything in return, and accepted by or on behalf of the other person. When the other person also accepts that gift, it becomes completed. When a Muslim transfers his property through gift, this transfer is called as hiba. The religion of the person to whom gift is made is not relevant. I think you remember this, we discussed in Transfer of Property Act as well, that in case of hiba, it's only important that the donor is a Muslim or a Muhammadan, but the donee may be professing any religion. There is no restriction as such. So Muslim person transferring the property will be called as Hiba, but it does not matter to whom property is being transferred. That other person is professing what relation. If the transferer is a Muslim, the gift will anyways be considered as Hiba. Thus, yeah.
Wait a minute. Here, donor from any region, but donor from any region, donor could be from
Donor should be Muhammadan. Who is giving the property, that person should be Muhammadan. Whoever is accepting, that does not matter.
Okay.
Donor, the one who is giving, he should be Muhammadan. Other person may be anyone. So where a Muslim makes a gift of his properties in favor of a Hindu, the gift would be considered as Hiba. In India, the subject of gift is governed by Transfer of Property Act, Chapter 7 of the Act, which is applicable to with regard to gift made by any person in India, irrespective of the person's religion, caste, or creed. But there is this exception or saving clause as well, which says that regarding Muslims, when donor is Muslim, this provision will not be applicable. So this part basically you can write in intro that this is the general rule, but then for Muslims, there is an exception that their own personal laws will be applicable. And for that, Transfer of Property Act also gives a saving clause that these provisions are being saved. Otherwise, remaining things, Transfer of Property Act will be applicable. So regarding Hiba, we have three essentials. First of all, qualification of parties, subject matter of a Hiba, and formalities of Hiba. These are the three things which we need to satisfy for it to be completed. First of all, qualification of parties. Both for donor as well as doni, there are qualifications. Donor, as we know, he should be a Muhammadan. However, donor may be either male or female, married or unmarried. That does not matter. There is no restriction as such. Person who are considered major under Indian Majority Act 1875, that is at least 18 years of age, they are considered as competent to donate property or donate anything. So they will be able to donate something. Majority, same provision of Indian Majority Act 1875 will be applicable. The person making a Hiba must be owner of the property, which is the subject matter of Hiba. In gift also, we have seen that the donor has to be competent, plus he should be having the right to transfer the property as well. I cannot randomly pick anybody's property and then just gift it to someone. I should be competent to gift, plus I should be having the legal right to gift or transfer that property as well. Same applies with regard to Muslim law as well, that in Hiba, this person has to be competent, plus he should be owner of the property which he wants to gift. A gift made under compulsion is not valid but voidable. Again, like in Indian Contract Act, what happens if my consent is not free? It was obtained by way of coercion, mistake, misrepresentation, fraud. Then in such cases, it becomes voidable. I have the option of deciding if I still want to proceed with it or not. Same applies with Hiba as well. If the person did not voluntarily give something, but rather it was taken from him, or he under compulsion he had to gift the property, then in such cases it will not be considered as a valid gift but rather voidable. Donor will be having the option of deciding whether he is okay with the gift anyways or he wants to take it back. Accordingly, provisions would apply. So free consent of donor must be present. Free consent again here also It's very important. What is free consent? Same provision from Indian Contract Act we can refer to. So donor's capacity, he must be a Muhammadan. He can be either male, female, married, unmarried. At least 18 years of age. Owner of the property. And free consent. These are the things that we need to satisfy. Muhammadan, male or female, married or unmarried, above 18 years of age, transferring his own property with his free consent without any sort of coercion, mistake, misrepresentation, fraud, or anything. In such a case, gift will be considered as valid. That is qualification or capacity of the donor. For donee also, there are certain qualifications that donee may be a Muhammadan or non-Muhammadan. So donee may be a Muhammadan or not non-Muhammadan. There is no restriction as such. After completion of gift to a non-Muhammadan, the property will be subject to personal law of the donee. The donee may be either male or female, married or unmarried. A donee may be a major or minor having soundness or unsoundness of mind. Someone else also may accept the gift. So that does not matter whether donee is major or not, donee is mentally sound or not. Those things also does not matter. Once this property is being transferred to the person, like from a Muslim, property got transferred to a Hindu. In such a case, once this transfer is done, we would consider that this property now belongs to this Hindu person. So Hindu personal laws would be applicable after the property is being transferred. Once this transaction is completed, Hindu personal laws will be applicable in terms of this property, how to deal with the property and everything. Okay, so whatever it is, in case of Parsi, Christian, whatever it is, their own personal laws will be applicable in terms of that. Okay. So it may be major or minor person having soundness or unsoundness of mind, does not matter that much. So first one is qualification of parties. Both for donor and donee, we have certain conditions or qualifications being mentioned. Now, subject matter of Hiba. A Muslim can make a Hiba of the whole of his property. For every form of property or right which has some legal value may be subject matter of Hiba. What is it that we can gift? There is no restriction as such. Whatever is like getting recognition in the eyes of law, those can be considered as a valid subject matter of Hiba. In case of will, there is a restriction, right? A person cannot alienate his entire properties to some stranger by way of will, because it would affect rights of his legal heirs. There is a restriction that if it's more than 1/3 of the property, then consent of the legal heirs also would be needed. If they are okay, then only property would go to a third person. But in case of Hiba, we don't have any such restriction. If the Muslim person wants, he can donate or he can gift his entire property as well. There is no restriction as such. So subject matter of Hiba may be entire property that a Muslim is having. It may be movable, immovable, tangible, intangible, whatsoever it is. Every form of property or right which has some legal value may be subject matter of a Hiba. Whatsoever it is that may be acquired by a person, transferred to a person, and which is having some value, which would be somehow useful to the person, every such thing may be subject matter of Hiba. However, the property must be transferable under Section 6 of Transfer of Property Act. These legislations are also related. Even though gift is provisions of Transfer of Property Act is not applicable in Hiba, but still what can be transferred, what cannot be transferred. There are some general rules mentioned under Section 6 of Transfer of Property Act, right? That a right to file a case cannot be transferred, right of space succession cannot be transferred. There was this long list of things. Same those provisions, even a Muhammadan cannot also transfer. Those provisions would apply, that these are the restrictions which are given under Transfer of Property Act, and those same restrictions will apply in Hiba as well. The property must be transferable under Section 6 of Transfer of Property Act. It should not fall under any of those exceptions. Tangible as well as intangible property may be the subject matter of gift. It may be tangible, it may be intangible, which we cannot see, touch, or feel, but still this right exists, right? Intellectual property rights, those also may be transferred. Or in case of a person's right to claim some money, or a person's right to like a file, a person's right to claim for recovery of money, those things are what, it's just a right that the person is having. Right to redemption, those are just some rights which we cannot really touch, see, or feel, but still those are also rights, those also can be transferred. Whatever is mal according to Muslim jurisprudence can be lawfully subjects of gift at Muslim law. So whatever is basically an object that someone can hold can be transferred to someone else, that may be a subject matter of gift. Okay, which would add value to another person, that itself can be transferred and can be a subject matter of gift as well. Then we have formalities of Hiba. Under Muslim law, for validity of a gift, there are certain formalities that need to be completed or done by the parties. Clear and unequivocal declaration by the donor. Such declaration may be made orally or in writing. How are you gifting the property? There is no restriction as such. It may be an oral donation. It may be that in writing with proper papers and everything you are doing it. You can do it your own way. A clear and unequivocal declaration of intention of making a gift by donor or his agent at first is essential element of the validity of gift. It's very important that clearly you are like gifting the property without any sort of question or without any sort of doubts. That is the reason why in case of gifts, it's clearly mentioned that I'm gifting this thing with my like full consciousness, in with free consent, without anyone influencing me, without anyone forcing me and all that stuff. It's very clearly written just to make it very clear and upfront that yes, I'm giving this thing as gift with my own free consent. There is no question of fraud, force, undue influence or anything like that. So it's very essential for regarding formalities of gift that it's clearly written, whether oral or written, it's clearly mentioned that with my free consent and everything, I'm gifting this thing to you. Such declaration of intention must be bona fide. In good faith, it should be done. It should not be that like fake document or something which with a bad intention they are doing. Those things should not apply. Acceptance by donee. The second condition necessary for validity of a gift is acceptance by the donee or maybe agents of donee if there is any. Such acceptance may be made expressly or impliedly. Acceptance is not required in following cases. Otherwise, person need to accept it. He may not clearly say that, okay, you are gifting me this, thank you so much, I'm accepting it. Those things might not be there. Simply, it may be express acceptance also. If the person is not refusing or something, oh, is it? Then also it would be considered as acceptance. It may be expressed or implied, but the donee need to accept the gift also. But there are two cases where acceptance is not needed. First of all, where gift is made by guardian to his ward. When a child is under custody of a guardian and guardian is gifting something to the ward, in such a case, acceptance is not needed because obviously guardian would be thinking good for the ward only. So whatever is the gift, it is considered that it's for benefit of the ward only. So there is no question of accepting and all that thing for the gift to be valid. A gift may be made by the guardian to ward, and in such cases, acceptance of the wards is not necessary. But if gift is made to minors other than by guardian, then acceptance of minor would be required in such cases. Because in such cases, we do not know what sort of gift it is. Sometimes gift also may come with obligations or some liability. So it's very important that gift is accepted by the parties also. Secondly, where the gift of a debt is made to the debtor. So someone has taken an amount from another person, he is the debtor. Now, gift of the debt is made to that person. A gift of debt may be made to the debtor. In such a case, acceptance of the debtor is not required, but a debtor may refuse the gift of the debt. But a surety is not released from the debt unless and until the debtor accepts it. In case, take for example, I had taken some amount from a person. Unless and until I repay that amount, I am having an obligation to pay it. If someone else comes and tells me that, okay, fine, you need not worry, I will be clearing out that payment. In such a case, my acceptance will not be needed because it will not create any sort of additional obligations on me. Obviously, this person is trying to reduce my burden. So in such cases also, it's fine even if I'm not accepting, like my express or implied acceptance is not required because that gift is nowhere creating obligation for me. But just because someone has said that I will be making the payment, I will be clearing this responsibility or obligation of yours, that does not mean surety is released. Whoever is giving surety that yes, this person will be clearing it, that person will not be released from his liability unless and until unless the debtor accepts it. If I accept the gift, only in such a case this person will be released. Okay, fine, I'm accepting it, you make the payment and everything. Then only surety will be released. Otherwise, if I'm simply listening, in such cases, he will not be released because there is a possibility at a later stage, I may say that, no, I don't want to do it. You won't I don't want you to do it. I only will do it. So basically, there are two situations where we do not need acceptance by the donee, and it is only because it's expected that in these two cases, the gift will not create additional obligations or gift will not be against the person. It will be for benefit of the person itself. So it's fine even if acceptance is not there. Okay, otherwise we have clear and unequivocal declaration by the donor. There should not be any question regarding the intention of parties, whether they genuinely wanted to gift or other stuff. Then we have acceptance by the donee, like other provisions under Transfer of Property Act also. It's very essential that parties accept the gift. Thirdly, we have delivery of possession. A gift is complete only after delivery of possession. So the third and most essential condition required for validity of gift is delivery of possession of property, whether it's movable or immovable. A gift not accompanied by possession is void ab initio. Under Muslim law, a gift is completed only after delivery of possession. Until the moment I'm delivering does not matter. Even if I had said that, yes, I'm gifting this thing to you, that thing to you, that those things does not matter. Only when I have actually delivered the possession, only when I have actually delivered the movable property, in such cases only it would be considered that, yes, now is the time when gift is being completed. Otherwise, it's as if like it never existed. Court would say that, okay, fine, might be this person had said that, okay, I'll give everything that I have to you. But that would not have any sort of validity or strength until everything is really transferred to that other person. Okay, so this is the third essential: clear and unequivocal declaration by the parties without any sort of doubt, without any sort of influence or anything. It is being gifted, accepted by the other person also, and finally property also is being delivered to the party. Okay, so these are some essentials which we have. Next we have is revocation of gift. After making the gift, is it possible that we again revoke it or we again take back the gift? So under Islamic law, all voluntary transactions are revocable. Whatever we are doing with our free consent, freely we are doing voluntarily without expecting anything in return, those are revocable transactions. Therefore, this revocability should also be attributed to gift. So same provision of revocability would also apply in gift also. Gift is a voluntary and gratuitous transfer of property without expecting anything in return. I'm gifting something to a person. The donor makes the gift of properties of his own free will and transfer without any consideration and exchange. The person with his own free will, without anyone's influence or force, he himself transfers the property without expecting anything in return. So in such cases, it is a voluntary transaction and it may be subjected to revocation also. In transfer of property by way of gift, there are basically three stages: declaration, acceptance, and delivery of possession. I declared it, the other person accepted it, and there is delivery of possession. Basically, these three formalities only we are mentioning here. As we have discussed earlier, that without delivery of possession, there is no gift at all. Even if whatever the person had said, I will be gifting all the properties that I had whatsoever, that does not matter unless and until there is delivery of possession done based on the statement made. So it's not even considered as a gift, just simply saying that I will be gifting everything. Unless and until it is actually being gifted, it's not even recognized as a gift also. So there are two ways of revocation. First one is like based on time frame, these different types of revocations are there. First one is revocation before possession, before handing over possession, and second one is When delivery of possession is being made, after that, how to revoke the property. Revocation before delivery of possession. Delivery of possession is only the formality or the final step which will make the gift completed. So before delivery of possession, all gifts are revocable, as it's not even considered as a completed gift. It's just a statement which you said that I will be gifting this thing to you. But this did not, like you did not execute it basically. It was just a statement. So it's not considered as a gift also, and these gifts are revocable. A gift may be revoked by the donor at any time before delivery of possession. A mere declaration of the donor that he has revoked the gift is sufficient, and accordingly it will be applicable. So person can just say that, yes, I'm revoking this particular gift and you will not be entitled to it. That is enough. That statement from the donor is enough to revoke a gift before delivery of possession. Second type which we have is revocation after delivery of possession. When delivery of possession is made by the donor, the gift becomes completed. It is the third and final step of formality that the donor needs to satisfy. After the delivery of possession, a gift cannot be revoked by the donor through mere declaration. For revocation of such a gift, there are two ways. Although there is a tradition that indicates that Prophet was against revocation of gift, it is a well-established rule that all voluntary transactions can be basically revoked, and person can revoke those gifts as well. Mere declaration of revocation by the donor, institution of a suit, or any other action is not sufficient to revoke a gift until decree of court is passed revoking the gift. So party can approach the court and say that this is something which I gifted and I don't want to I don't want to continue with it. I want to get this thing back. So based on court's order also, it may be revoked. If court feels like, court may pass it. Like it's discretionary power of court. If court feels like, then court can grant this, accordingly grant an decree, and same based on that only, it will be revoked. Revocation of gift is a personal right of donor. Whoever was gifting the property, it is that person's right only to revoke the gift at a later stage. So gift cannot be revoked by his heirs after death of the person. A gift cannot be revoked after death of the donee also, but there are some exceptions. These different schools are having different thoughts or different philosophies. So some exceptions might be there, but general rule is that it's one person who made the gift, another person who accepted the gift. So once those two persons die, their legal heirs or their other representatives, they cannot do anything with regard to the property. What is gifted only. They cannot say that, okay, now we don't want to gift it or something like that. Like it happens in terms of will. If the deceased person had gifted, like had said that, okay, entire property would go to the stranger, in such cases, legal heirs are having a right to object also, that no, we do not approve this sort of a will, and they accordingly can claim for their rights. But in terms of gift, it is not being provided. Whatever is done by the donor, that itself will be considered as valid here. This is clear, right?
Yes, madam.